All right, good afternoon, everybody. This is Kathy Purdy. I am the Marketing Supervisor at Schoeneck King. I'd like to welcome you again to this week's webinar on coronavirus and related issues. Just two quick housekeeping items, which I'm sure most of you know by now. Any questions that you have, please submit them through the Q&A box located at the bottom of your screen, and we will do our best to get to those as time allows. And second, if you would just take a moment to complete the brief survey once the webinar has ended, we would appreciate that. So we have a lot to cover today, so I'm going to start things off by introducing Pete Jones in our Syracuse office.
Thanks, Kathy. Good afternoon, everyone. As Kathy said, we do have a lot on tap for today. You know, one of the things that we have covered independent of this, you know, an entire webinar, and probably will be doing more, is school reopening. But it's on everybody's mind, both because, you know, it's an important harbinger of where we are, but also because it is so interrelated to people's availability in the workforce and what's on people's minds with respect to their home life. So we'd like to start off today with Bethany Centrone. Bethany is in our Syracuse office and also out of our Rochester office, a school law expert, and she's going to walk us through what we know and I think, unfortunately, some of the things that we don't yet know. Bethany, take it away.
Sure. Thanks, Pete. Good afternoon, everyone. Thanks for joining us. You know, right now we are in the throes of evaluating and assessing hundreds of pages of guidance documents that have been issued by the State Education Department and the DOH, combining all of the guidance that is out there. Last week, the DOH issued about a 22-page guidance document that also referenced many guidance that was previously issued for industries that are going to be applicable to schools. And then a few days later, the State Education Department issued 145 pages of guidance to try to assist schools in their reopening plans. What we know right now is that those plans are due to be submitted to the Department of Health, through the governor's office, essentially through the state, and to the State Education Department on July 31st. Both guidance documents do require, do require that school districts obtain stakeholder input, and that is parents, teachers, staff, health experts, school nurses. The list is very, very long. Most school districts, at least in my experience, started this process quite a while ago, probably at the end of May, when the governor first issued statements that these plans would be required without particular guidance. And luckily, the state is referring to prior guidance issued for food service and office workers and the like, because I think most of our school district clients had been looking to those for some kind of idea about what might need to be done, since there hadn't been any school-specific guidance issued yet. Once those documents, and they're required to be very specific in relationship to what's out there, are created, they're supposed to be posted on each of the school districts' websites. The general gist of the areas that are contemplated by the guidance includes, as would be expected, social distancing requirements, the use of face coverings, the use of barriers, and the use of cleaning and disinfecting protocols that are out there. There are some competing information in the DOH guidance and the SED guidance about what is actually required and what is recommended in relationship to social distancing. And school districts are going to be needing to work through that as they move forward, and some additional FAQs that NICET is sending out and adopting to try to adjust those differences. But in terms of reopening, school districts are required in schools. There may be charter schools. There is some guidance that has not been released yet in relationship to private schools that may be state approved. It's expected that it would be very similar to what is being issued for public schools as far as safety precautions go. But schools are expected to submit plans for every contingency, so fully remote, fully in-person, and then what they call a hybrid model, which is both in-person and remote. Most school districts are looking at hybrid models in relationship to needing to keep the concentration of individuals and students in the buildings down, to ensure that that they have appropriate social distancing, or try to get appropriate social distancing, which is, again, what that is in flux at the moment. But even without the requirement, I think most school districts are going to be working to make sure that the concentration of students in classrooms is sufficiently low to have some distance between their students. These plans, or any in-person plans, are preferred by the Department of Health guidance, certainly strongly preferred by the Department of Health guidance, and sort of impliedly preferred by the Department of Education guidance, but can only go forward in person, as many know from news reports, if the infection level in New York State stays below 5%. Upstate here in our area is pretty far below that. I think we're less than 1% or at 1% in this area. So it looks good that would continue to be able, we would be continue to be able to reopen in at least in our areas and others in the state. But if we do see a surge in infections closer to September, then the possibility for in-person instruction may fall. Furthermore, schools will have to close if they become in a general region, if that region becomes rises to the level of a 9% infection rate, which is why school districts are required to have those hybrid models and have contingency plans of what to do if schools are closed regionally, and if a particular school might be closed. For example, if students are, if a student or an employee in the school building becomes COVID positive, and there has to be a closure for a period of time so that the schools can be disinfected. Other things that are mandatory in relationship to these plans, I'm sure that in these we've talked about the screenings that are required for employees to come into buildings and to return to work. Those health screenings are going to continue to be required for all employees and vendors and visitors that come into school buildings. The guidance says periodically for students, and those are the typical screening questions. Have you had symptoms, or do you have symptoms of COVID? Have you been exposed to somebody that has been COVID positive in the last 14 days? Have you tested COVID positive, and have you traveled to locations that are restricted? In addition, people who enter school buildings, all students and all staff have to have daily temperature checks. And if they have a fever of 100 or over 100, we were just having a conversation about whether it's 100 or more or over 100 in a school attorney conference just right before this. Those students will have to be excluded from school, and employees who have that temperature would also have to be excluded from work and sent home, or first isolated in the building and then sent home immediately if that's the case. There's time limits again for those who either screen positive, answer the questions, or test positive. You're required to, students would be required to not come to school for at least 10 days from the start of their symptoms under the guidance, or 3 days after their symptoms improve, or they have last had a fever without it being the result of taking medication. Again, what we don't know as far as the guidance is, how the approval process will work. Immediately, the guidance indicates that once submitted, they're approved, but they will be evaluated over time. So it's certainly possible that plans that are submitted as of 31st may be under review and need to be reevaluated. It's uncertain how much stakeholder input, given the timelines that the governor had, would be considered sufficient in relationship to these. The other significant issues with regards to the guidance are who's been identified as vulnerable populations, and those would be students or staff, first and foremost, who they themselves have underlying conditions that make them at risk for severe illness if they're exposed to COVID-19. And again, another basis for schools to need to be able to have that hybrid model for distance learning or remote learning, so that those who are members of vulnerable populations can receive learning while they're out. The prioritized instruction as far as getting students back for in-person are students within the early grades, so our younger students who may not be able to access remote learning quite as much, or students with disabilities. Again, those students who can't necessarily access remote instruction as well as some other students in poverty who may not have the resources, and English language learners. Sorry, Pete, English language learners. So those are, I would expect that those would be the folks that would be seeing plans that come out to, and the students that would, when you see plans come out from your school districts, that those would be the first initial focuses on those plans, and then likely phased in-person instruction following that.
Bethany, thanks. A lot to digest there and a lot in flux. It sounds like we're just going to have to keep our eye on things. It's, I guess it's similar with all the other aspects of, this situation, that, what we know is what we know, and it evolves constantly, and people are going to need to be flexible as this thing progresses. All right, let's turn now to Krista Cook. Krista Richer in our Syracuse office. Krista is going to walk us through the higher education situation, and she's got some thoughts on assessing difficult issues in higher ed. Krista, take it away.
Thanks, Pete. Good afternoon, everyone. Thanks for joining us. Similar to what Bethany addressed, I'm going to stick with the reopening issue in the education context, but moving on to our higher education clients. Like Bethany and Pete had mentioned, the situation, like everything else with COVID, needs to be very fluid and very flexible. Things are changing daily. But our colleges and universities have had a little bit more time as opposed to the school districts. We are a little bit farther into this process maybe than the school districts as far as assessing the reopening. I'm going to just kind of address some of the top common issues that we've been seeing from our colleges and university clients. But before we get to that, just kind of a groundwork, where we are. There is a New York guidance, has issued guidance from New York that guides the reopening issues. There is a higher education summary guidelines. That essentially lists sort of mandatory requirements and obligations for colleges and universities, and then recommended best practices. And second, there's a New York Department of Health interim guidance for higher education during the COVID-19 public health emergency. And that was released on June 28th. That reopening guidance for our higher education clients also references 5 industry-specific reopening guidelines. So like Bethany mentioned with the school districts, the colleges and universities have to kind of refer back to other guidelines for food service and transportation, retail, for the bookstores, and those types of things. So it's very complicated. But once these reopening plans have been developed, they need to be submitted to the Department of Health for approval, and following approval by the Department of Health, institutions of higher education must post those plans to students and employees so they are accessible to the entire campus community. On a federal level, the CDC has issued some CDC reopening guidance for higher education clients that's on their website. That was issued at the end of June. And the American College Health Association also issued guidelines to help higher education institutions navigate some of these issues. So one of the issues that we have seen most come up with our colleges and universities is in getting people reopening and getting their faculty and staff back to work is the issues of accommodations. There's a whole host of accommodation issues that arise for health conditions that trigger both federal and state laws. And the obligations are essentially the same as those that apply in non-COVID situations. But we do have some unique applications in the current environment. And keeping in mind that, again, we don't know yet how the courts will analyze these accommodation issues in this unique time of a global health crisis, of something that's so novel and, that we've just never dealt with before. But we have some, we know where we've been on the accommodation issues. And one of the issues that, like Bethany mentioned, that higher education institutions are kind of struggling with or needing to work through is, again, the high risk or vulnerable populations of faculty and staff. The CDC has issued that list of underlying health conditions that are more likely to result in severe illness from COVID-19, as well as a second list that might cause increased risk to individuals. So I know a lot of colleges and universities have received a lot of questions from faculty about special arrangements, some modifications, due to the fact that maybe they have a vulnerable, they are within this vulnerable population. What's the framework? It's very basic. We have a duty to accommodate an employee based on the employee's own disability. Here are the underlying medical condition, subject to an undue hardship analysis. So we're going to go through the regular process of getting medical documentation, working with that employee, but the accommodation need not eliminate the essential functions of the job. Requires some discussion internally with institutions about, how much and to what extent is that in-person collaboration or in-person services, for example, like campus safety, require their presence on campus. If their presence on campus is essential, then the next level of analysis is a leave of absence. So those are the two things that are really at most discussion, is the remote work versus a leave of absence, once we've had the discussion about the underlying health condition. The other question that we have gotten a lot of is there an obligation to accommodate an employee who has a family member who is at high risk or falls within this vulnerable population? And the answer to that is no. There is no duty to accommodate in those situations. The EEOC has supported that. The EEOC has said that the ADA does not require an employer to accommodate an employee without a disability based on the disability-related needs of a family member. So there is no legal accommodation obligation I would just note that these state reopening plans, to make sure we're collaborating internally with your campus, because the guidelines and the reopening plans do address the vulnerable population issue. There's very little about that, doesn't give us much guidance, then leaves us back to what I just discussed is what your legal obligations are. Unless the college or university has gone beyond that and made an institutional decision to expand that accommodation to something other than what's legally obligated. Employee accommodation issues also become complicated with regard to faculty. There are many requests, for faculty requesting to work remotely. It's essential that we have sort of a consistent, each institution has a consistent analysis of that. Many institutions have taken the position that in-person, instruction is an essential function. That's part of the bargain that the college has made with their students. And other institutions have taken a different approach and been much more flexible. So just the communication and the consistency and where your institutional approach is on that, so that we can, the HR offices and representatives can stay within what the commitments we've made as an institution. One of the other interesting issues that we've come up with is particularly faculty requesting sabbaticals. Sometimes those issues are raised in collective bargaining agreements. So our higher education institutions need to look at the CBAs. What are those promises? What are those provisions? Is there discretion on behalf of the college to grant them, deny them? What is the discretion? What is the staffing issue? Is there operational issues for that? So overall, when we're dealing with those accommodations, consistency, making sure that like in non-COVID situations, we are, who is the request going to, making sure that all of the decision makers and contact points are on the same page, making sure that we're getting documentation, we're treating that medical information confidentially, and again, sort of making an assessment institutionally is, are we going to request, are all of those requests automatically going to be granted or not, and where's the what is our approach on those other issues. I want to touch on one of the issues that that Bethany had discussed with regard to school districts, right? It's top of mind for a lot of parents, working parents, but it's also top of mind for employers, colleges and universities included, because certainly school, childcare, and job responsibilities are very much intertwined. So that is something that colleges and universities, like other employers, are having to navigate in the reopening, thinking through what leave laws apply, what their internal policies might be triggered when to adjust for if school districts do implement a hybrid model where kids may need to be taught at home for part of the week, or in situations where kids test positive in a classroom, or some other child in the classroom, and the employee's child then has to be quarantined at home. So, it's the possibility that we could restart the schools and then only find the schools to be closed or certain classrooms to be closed. And colleges and universities, like other employers, are facing issues with, employees having this dilemma. So bringing back to mind the Families First Coronavirus Response Act. That's one of the issues that colleges and universities need to assess. Again, it applies to all employers with 500 or fewer employees. There is a portion of that act that is the emergency FMLA leave, and it provides employees with up to 12 weeks off at partial pay to care for children whose school or child care center has closed. Certainly this is something that may be impacted or implicated as our colleges and universities open and their own faculty and staff have these issues. So I know our HR representatives are determining eligibility, looking at did the employee take all or some of their emergency FMLA already. If they've used it up, they don't get a new pocket of time. It's only that portion of time, that 12 weeks. If it has been exhausted, there is no more leave that they're entitled to. Keeping in mind too that act is set to expire on December 31st of this year. So there's certainly some uncertainty of where we're going to be if COVID, continues into 2021, and whether the Families First Coronavirus Response Act is extended beyond its current deadline. We also will need to consider other leave laws like the New York State paid sick leave law if there are situations in which the employee's child is sick with COVID or is quarantined because of possible exposure at schools. So those are all issues that they're going to be, our colleges and universities are going to be facing for employees. Want to address another big issue that colleges and universities are facing with screening and testing. Very much like the school district level, there are obligations about how they are screening and testing for COVID, and that needs to be addressed in the reopening plan. How, if at all, the health center will assist in screening, that testing, the frequency of the testing, the method of testing. And one of the other issues that our clients are looking for some assistance in is considering negotiating vendor agreements or affiliation agreements with local hospitals and other facilities to conduct that testing, to help the colleges and universities sort of monitor and navigate those screening and testing requirements. The last thing I would mention is, and it's a little bit sort of different than the other topics, is in this time where colleges and universities are scrambling with the reopening plans, they're also scrambling to comply with an amendment to the Title IX law. And very briefly, that law goes into effect on August 14th. So all colleges and universities will need to have revised their Title IX policies, provided training, communicate with their campus community. So in the midst of all the reopening chaos, there is a lot to do on that front as well. So I think that's all. I think I'll hand it over to move on to some PPP loan issues.
Krista, thanks. Before we move on to Erica, just real quick, I wanted to grab a couple questions here and give quick answers. There is a question here about, reasonable accommodations being individualized, and the answer to that is yes. That hasn't changed. The substance of the questions may be a little bit different or specific to the COVID, situation, but reasonable accommodation is going to be a case-by-case individualized assessment. There was another question here about, do we want to revise our questionnaires, our screening questionnaires, to ask a question about where people have been with respect to the travel quarantine? I think the answer to that is also yes. I mean, we're going to need to know where people have been, and that seems like a reasonable place to put it. So with that, we're going to shift gears now. We're going to go to Erica Wood. Erica's in our Albany office, and one of the things that we've been dealing with is, transactions haven't stopped. People are still out there making deals, and the implications of the payroll protection program. So Erica, take it away.
So yeah, this is going to be a big shift from, some of the earlier presentations, but I know we've had several sessions with myself and other bond attorneys to discuss PPP. So it's only makes sense, I think, to update and discuss, the real-time effects in some current transactions. So I'd say I'm seeing this come up for sure in my practice right now. Who is the relevant audience right now? We're talking about any buyers or sellers of a business where a PPP loan was involved. And these could be transactions that, are picking up steam that might have been put on hold before COVID became a real issue, or they might be some acquisitions. I know there's some markets that I've seen that are highly active, say the pharmaceutical industry. And so there's deals that are picking up that may not have gone through before or been of interest, but there's some acquisitive purchasers out there. So first, I guess some background for, people who haven't been, so in tune with the PPP updates. One of the major changes that came about was the change and expansion of the covered period. So the covered period really is that testing period that we're concerned about. That's really going to be determinative of the amount of forgiveness that you're eligible for. So that's the period that you care about your number of employees and you care about how you're spending money during that time. So legislation expanded that from 8 weeks to, by election, 24 weeks. So obviously that's a very significant expansion of that potential period. So again, deals that might have been put on hold or that are popping up very well may be in the middle of their 24-week covered period, and this is going to be relevant. So I just want to go through kind of some main choices or considerations, some consents that might be considered, and then just overall considerations from either side, just highlighting some of the issues that, I've seen in practice. So the first is, we have a PPP loan and say you're in the middle of your covered period. Your choices are really, is the deal going to require us to repay it? Or are we going to keep it outstanding? And really, if we keep it outstanding, what does that mean? Does it mean that the purchaser is going to acquire the PPP loan and it's going to be assumed? What are we going to need to make sure of if that's the case? So really, that's an initial consideration. This isn't, your traditional funded indebtedness that you see in M&A transactions. An important thing at the outset is going to be considering for both sides, is approval required? So it's very likely that pursuant to your lender documents that you're going to need to get consent of the lender if you're planning on transferring ownership of the loan, particularly if you're looking to get the original borrower off the hook, which I would assume would be what you'd like to do if you're the seller. The other question is, do you need SBA approval? So if you're doing certain types of equity transactions or business formation changes, then you're going to need to get SBA approval. So who knows how long that could potentially take, could really create some complications in the deal. So that's something to think about at the outset, so you can have some conversations about, how the parties are going to handle that. Then, let's think about it through the lens of the buyer versus the seller. So if you're the buyer in a transaction, how's this going to change your process? It's definitely going to change your due diligence. You're going to be paying attention to, were they eligible for the PPP? Did they make the certifications? Did they look at the affiliation rules and all those complicated things that we've talked about in prior webinars? So that's going to be a new part of the due diligence, might be added to your closing checklist to you attorneys out there that are used to going through these types of transactions. Are you going to require certain protections? Do you want increased escrow if you're taking it on? Are you going to be looking for additional reps and warranties about the loan and again about these certifications and eligibility requirements? On the seller side, on the other hand, you're going to be looking at, some considerations are, what's the timing of all of this? Is this going to affect my purchase price? Are there going to be adjustments that need to be made? Again, do I need to obtain consent? And then ultimately, how will forgiveness work? So the borrower isn't going to want to leave money on the table, right? The PPP loan, when spent properly, is essentially free money from the government. And so the fact and thought of having to repay that can be something that's difficult for clients to digest. I actually just closed a transaction where the purchaser, for reasons related to the disclosure of the PPP loan program and the fact that they were a publicly traded company, just were not interested in negotiating taking on the PPP loan at all. And so that's a discussion, you might have to have, and some considerations you might want to have as you're crunching your numbers in a deal on the front end is, well, how is the PPP loan and whether or not I can get forgiven for it going to impact, how much and what my expectation is for a purchase price. Might be the deal is so great that you're okay with paying it back, but again, something that you're going to want to be considering at the outset of the transaction rather than, getting 3/4 of the way through and realizing you were treating this just like any other indebtedness and not realizing the level of complication that could potentially come up. So overall, if there's a PPP loan involved, that's something I would consider at the front end of any type of transaction. There's a bunch of different ways that you can structure around it and protect for both parties and facilitate a good result. And this is something, the attorneys at Bond have a lot of experience working on right now and are happy to help you with if this comes up for you. With that, I will pass on to the next presenter, which I believe is Katie.
Yeah, Erica, thank you. We're going to have Katie give us a little update on what's going on in Albany, and then we're going to, if folks can stick with us, we're going to have Lou DiLorenzo wrap up today on some labor and employment retaliation issues, things to keep on your radar screen. So please stick around. Let's turn it over to Katie.
All right. Well, hello, everyone. If you wanted to know where I was last week, this is where I was. I hiked up Mount Washington, so that's why I was not here. I wore my Bond mask, and I was very out of breath the entire time. So hopefully I'll be less out of breath for this. I'm not moving as much. First thing to know, Phase 4 everywhere. Congratulations to New York City. You still can't go to museums or do indoor dining. New York City also has certain restrictions about indoor activities as well. But you can go to botanical gardens, zoos. You can go to Liberty Island. You cannot go inside of the Statue of Liberty. So that's, there's more going on, but what's going to be really, important to watch is what's going to happen with bars and restaurants. Yesterday, the governor gave quite a remarkable press conference before you went to Georgia. And in that press conference, and again today in his news availability that he had with reporters at 11:30, he emphasized that bars are being a problem. There's a problem with bars. Today, SLA announced, the State Liquor Authority, they've announced that they're suspending 4 liquor licenses. 3 are in Queens, 1 is in Suffolk County. I expect that we're going to see more of that, especially now. This executive order came out last week. There's been lots of pushback on this executive order, but basically the point of this order is when you go out to get a drink, you need to be eating. You need to be seated at a table. You can't be up in a bar walking around. You can't be, the point of it is you have the food and people are supposed to eat that food at the table. What's interesting is that depending on the license of the establishment, different food may be offered. So manufacturers with on-premise licenses may offer sandwiches, soups, or other food that's ordinarily given with a tasting. So think of a winery. Many of us people living in upstate New York have gone to Finger Lakes to go wine tasting. There's often a bowl of crackers there. That type of a thing, offering somebody an individual pack of crackers or potentially crackers for the table to share, that may be offered. So what's going to be, I expect that SLA, the State Liquor Authority, is going to put out more guidance on this supposedly today or tomorrow. So we're going to see some more nuance here. But what's interesting is that on-premise retailers, so that's your regular bar or restaurant, must offer soups, sandwiches, or other types of food of that vein. So it's less the finger food, it's more meal adjacent in those areas. So that's going to be a change. You've seen a lot of pushback on it. That's not going to change. This slide is already out of date. I did this slide this morning. The governor added 10 more states today. We are at a total of 31 states that have the travel advisory now. The 31 states, 10 were included today. I wrote them all down. So first up, we had the removal of Minnesota from that list. Delaware was re-added to this list. Alaska, Indiana, Maryland, Missouri, Montana, North Dakota, Nebraska, Virginia, and Washington State. Interestingly enough, Kentucky was not added to this list, even though Kentucky does have the correct numbers. The reason for that is because Kentucky didn't update their numbers on Sunday, so they updated their numbers today. So their 10-day rolling average is a little different. But I expect that Kentucky will be added next week. The positive note is that there are only 49 states that can be added to this list. So at some point it will end. One other thing to note too, just as a general inquiry about travel advisory stuff, remember that you are required, if you're traveling to New York via an airplane, you have to fill it out in the airport. If you're driving to New York from one of these states, you have to, taking a train or whatever, you have to, upon your arrival in New York, then submit the form online. And that's a form that you can find on the New York Department of Health website. They make it very easy to find. Just Google New York travel advisory form, and that's it. So with that, I will cede my time and have a great day.
Thanks, Katie. Appreciate it. A lot happening as always, and frankly, a lot to just keep our eye on. Continuous tweaks. I think the governor mentioned this when he talked about reopening, kind of opening the valve and closing the valve, and I think we're seeing some of that here. All right, we're going to shift gears here one more time. We're going to go back to, or we're going to go to Lou DiLorenzo. Lou is in our New York City office, and everyone probably knows Lou, or a lot of folks do. But Lou's going to give us some insight into retaliation claims, some things that I think we're continuously worried about. Take it away, Lou.
Okay, thanks, Pete. So why should we be worrying about, with all the things we've got to worry about with the virus, why should we be worrying about retaliation in particular? Well, a couple of reasons. One, retaliation claims, every year the statistics come out. We just got the 2019 statistics on discrimination complaints. And by far, retaliation claims is the number one category, followed afterwards by race, disability, sex, age, national origin, and religion. And that was, can't forget, that was in a year of, the second year of the Me Too movement. Retaliation is still going away, the most frequently filed claim. Those of us that can remember back before the virus hit, there was the impeachment of the president, and day after day, we heard about whistleblowers. It's a phenomenon that's not changing. It's growing in terms of frequency. And we have, of course, special events presented by the pandemic. First, you've got a number of unknown risks from the virus. People are, this third bullet says return to work as a change after 5 months. So for 5 months, people have either not been working or were working remotely, and now they're being asked to go to work, to, in New York City, for example, use public transportation, those kinds of changes. Today I put a tie on for the first time. Everything's changing. And when there's change, there's uncertainty, and people get concerned about things. And with the unknown risks, because of the safety factor, I think you're going to see more and more complaints from people that they're being asked to do things that are unsafe, whether it exposes them or their family or people they're taking care of, all those kinds of things. In addition, you're going to have a very sympathetic market, if you will. I think juries, judges, unemployment insurance judges, New York State Division of Human Rights investigators, people are going to be very sympathetic to people, whether they're in a risk category or not, sympathetic to their concerns about things that they believe are unsafe and they shouldn't be forced to do. At the same time that's going on, we've got millions of high-risk transactions in the employment world weekly. I mean, every week we continue to see million million or more unemployment insurance claims being filed. These numbers, so when you're a labor lawyer, you think about two things that create high potential for liability. One is somebody getting fired or losing their job, or you stop paying them for some reason, or we have a chance to pick among people to hire someone or bring someone back to work. That's the other high risk transaction, hiring and firing. And basically that's happening at an unprecedented amount of transactions every week during this pandemic, right? I mean, we've never had this many people go out of jobs and come into jobs, staying home, selected, not selected, probably since, the Great Depression, and we didn't have the kinds of numbers of people that we do now. So all that friction is occurring with high risk employment movement. People being selected for layoffs, selected for furloughs, recalled from layoffs, recalled from furloughs, all those kinds of things. In addition, we've got a very tight job market, right, with the numbers of unemployment that we have and people not working full time in terms of how much work people have available. I see a lot of whistleblower complaints where people file because they sense they're going to be losing their job, or they're on weak ground, or they may be picked for something. They may have good reason to believe it or not good reason to believe it, but they will file for some kind of self-protection. Whistleblowers today understand that they get a great deal of protection under the law, retaliation and whistleblowing. I put in this parentheses on this slide, the concept of looking backwards. The other reason, my experience over several decades, is we get more complaints when the market is tight. If people lose their job and they move on to another job, maybe they make as much money, more money, they like it more than the job they had behind us. They look out the windshield of the car, the front window, instead of looking in the rear view mirror as to what kind of job they had before, what kind of a claim they may have had. But when you don't have job opportunities going forward after you lose your job, you end up, more people end up looking into the rearview mirror and saying, I had that great job, I had all those great benefits, I lost them, I can't find something to replace it, so I'm going after that employer. And one of the things that turns up is the possibility of retaliation claim. If we could take a look at the next slide. Another reason to worry is that compliance in this area, I mean, we just heard Erica, Caitlin, Krista, and you've been hearing them for weeks. Being in compliance with the law is not very clear these days. We've got all these executive orders that are out there. We've got different statutes that have been passed fairly quickly. We've got regulations that change every day, every week, the CDC guidelines, OSHA requirements, New York State requirements. They're not, so that line is a little blurry in terms of people not understanding if they're safe, not understanding if something that we say we can do in our industry with respect to reopening may not be as clear as a bell. And so people are raising complaints. People legitimately think some things are unsafe, or illegitimately think they're unsafe, and they file complaints, they make complaints, they set up a Facebook post to gather all their co-employees together in this activity to try to stop something they believe is not safe or not being done according to Hoyle. We've got reopening plans and rules. People are going to say that we're not following, or there's been some technical violation, or something that's being followed, all those kinds of things. We've got all the issues. Krista talked about some of them, the application of existing statutes to the pandemic. So we've got statutes that have been in place. The Family Medical Leave Act with its extension, OSHA, Americans with Disabilities Act, National Labor Relations Act, Fair Labor Standards Act. These come into play in a number of situations: unsafe working conditions, complaints under OSHA, a denial of someone's leave under the Family Medical Leave Act, or some adverse employment action being taken to them after they've been out on leave or requested leave, whether it was granted or denied. Same thing under the ADA, where somebody's asked for reasonable accommodation, whether it's granted, not granted. National Labor Relations Act, we've seen probably more safety strikes and refusals by people to work under the National Labor Relations Act than we have in decades. I think you're actually seeing unions achieving some footing in this climate, because they're offering people who are concerned about the safety issues another avenue of safety, another avenue of protesting or putting pressure on the employer to change something that a group of people or two or more people perceive as being unsafe. And of course, we have the Families First statute, the new statute, which provides protection to people under the leave provisions and denial of leave and retaliation under that statute as well. Of course, we have the New York State statutes. We have the New York State human rights law. We have the workers' comp law. I mean, I think we're going to see an increase in workers' comp cases where people claim that they got the pandemic at work. They're protected by an anti-retaliation statute in the workers' comp law. People can't be fired because they have violated, because they filed or attempted to file or threatened to file a workers' comp claim. New York has two whistleblower statutes. They're fairly narrow in scope. One deals specifically with healthcare employees. The other one deals with something that creates a public health hazard, which could include aspects of the virus. Those statutes are there. I think you're going to see them used by people. So what should we do? So we've got these concerns. What steps can we take? Obviously, following your rules and your return to work plan as best you can, enforce it consistently. So you're not in a position where you're susceptible to a whistleblower claim or some claim by someone that you're not following it. And also the indication that I wouldn't be firing somebody for rules I'm not following. We have the plan, we follow it. That's a very important goal of our organization, and it makes it unlikely that you're firing people because they're complaining about safety. In addition, you want to take a look at what policies you have which may be impacted by the virus itself. If you have a teleworking policy, if you have an accommodation policy, the EOC guidance that's been issued, make sure your policies are consistent with what the new thinking is under the coronavirus situation. I've had clients where we've had to change the telemarketing policy because we actually prohibited telemarketing in almost all cases. And of course, the virus flipped that on its head, and for a while we had almost no one working other than teleworking. So you want to make sure the policies are not. And when someone refuses to come to work, has no excuse, and you end up taking some adverse action against them, you want to make sure you don't have a policy that says, I'm against letting people work from home if you've denied them that accommodation or refused to allow them to do that. We've had several situations where the guidance has not been absolutely clear on opening a business. There's been some conflicting areas of direction in terms of what we could do under phase 3 or phase 4. And we've had people that have said, look, I read the governor's executive order. I've looked at this thing. I made some phone calls, and I'm not going to do that work. I'm refusing to do that aspect of my job. In several of those cases, for example, we've reacted in different ways, but we've held off terminating people because I don't think that's a case we want right in the middle of this pandemic. In some cases, for example, we've given leaves of absence. We've put somebody on a leave of absence without pay. They haven't been terminated, but we think we have the right to require our employees to do this job in this manner. You don't, and you have that right. But if you're refusing to do the work, then we don't have a job for you because that's what your job involves. And so until further notice and until things return to normal, and we're not going to have this issue of whether the virus permits or doesn't permit that work to be done in that way, you're going to be on a suspended leave of absence without pay. And fortunately, the clients that I've been counseling have agreed to continue our share of health insurance only because I am concerned about putting people out to pasture in the middle of a pandemic without health insurance, and how that's going to be looked at by decision makers or fact finders later on. Think about broad accommodation. Krista talked about the requirements that, we only have to make reasonable accommodation for a health condition of the employee. It can't create undue hardship. We don't have to do it for those reasons, but rather than focus, and she's absolutely right. I mean, those are the legal requirements. But what I've been trying to advise people is, look, let's take a broad, if we can, if the organization and our operation permits it, let's take a broad view of accommodation. And let's accommodate people for a lot of reasons if we can, even if they're not specifically covered by the statutes. If they're over 65, if they're taking care of someone who has high risk issues, autoimmune system type of problems, and so on. If we can accommodate that, let's accommodate it. Whether it's working remotely or a leave of absence or some other issue, rather than take the position that they're not entitled to accommodation. And so their choice is either to work, or frankly, they're quitting their job, or we're having to terminate them because we don't have any other work for them. So be slow to fire. And slow to force changes on people. If people are having a hard time coming back to work, you can still get the work done in most cases and have them accountable for the work that they do. If you can, move slow in those things. If you can't, it's a different story. But to the extent you can, it's a good idea. If you decide not to give someone accommodation, document the process that you follow, that you engaged in the interactive process and the reasons why we decided to deny it. If you get whistleblower complaints, document those complaints, investigate them. If you fix something as a result of the complaint, make sure you document that. Or if your findings are that there was no basis to the complaint, document those. Dust off your complaint procedures in terms of internal whistleblowing, internal complaints being made about violations of the law or safety. Make sure you train and educate your supervisors so they know we are interested in taking those complaints. We're not trying to dissuade people. We'd rather get the complaints than the Department of Health or the Attorney General's office or a union or a plaintiff's lawyer or someone else. So make sure the supervisors understand that we're receptive to those complaints, and make sure the procedures are up to date. Be mindful of intervening events, temporal proximity, avoiding adverse action. The temporal proximity on a complaint and an adverse action is a killer in these retaliation cases. But keep in mind, if there's an intervening event that is really, if you have protected activity and then you have adverse action, if between those two you have an intervening event, that's great for us. Obviously, it breaks the chain, the causation change between the temporal proximity and the adverse action, but also it creates new temporal proximity. The action that we took is closer in time to the intervening event than it is to the original protected activity that was engaged in. So keep that in mind. And we want to avoid adverse action wherever we can, whether putting somebody on a leave of absence without pay, giving them a different work assignment but keeping their pay the same, making a lateral transfer, whatever we can do imaginatively that eliminates actual damages or an argument that can be made that they suffered adverse action, that can keep us away from liability. I'll stop there. And turn it back to Pete.
Lou, thanks. And thanks everybody for being with us today. We are continuing to try to give you a lot of different content and a lot of different perspectives. So we do apologize when we run over a little bit, but it's in the spirit of trying to make sure that everyone's got the latest and most up-to-date information. Thanks everyone for being with us. Look forward to talking with you again next week, and stay safe.